I thank you for these gracious introductions, and I want to thank the NUS Law School faculty for inviting me back to Singapore. I do want to note that the course that I'm teaching has given me an opportunity to deepen my understanding of the Singaporean constitutional order. This article that was mentioned, I would write somewhat differently now. After it took me about 10 years to be confident enough to write the article, and another 5 years I would modify it some. So I appreciate the opportunity to be here. The final preliminary note that I want to make is that the book that Professor Harding mentioned, the history of the United States Constitution, a contextual analysis, is one of my favorite of my own works. So I really appreciate that he invited me to write it and sort of got me to think comprehensively about what I thought about the U.S. Constitution. Okay, so tonight's lecture is about the future of separation of powers, and it's part of it's really the first installment of a larger project, the size of which I don't really know, on these things that I call, relying on the South African Constitution, Institutions for the Protection of Constitutional Democracy. The acronym is IPDs. I drop out the constitutional because 3 letters is better than 4, basically. It's easier to say IPDs than IPCDs. And so here's the background of this. In the 18th century, Montesquieu famously set out 3 functions that all governments must perform. I should note, this is a modern formulation of what Montesquieu presented himself as doing. So he said, there were these 3 functions, and they were associated with 3 branches of government. The legislature makes general rules, the executive applies rules in particular circumstances, executes the law, and the courts resolve disputes over the rule's meaning. Over the course of the 19th century and into the early 20th century, Montesquieu's conceptualization, again, as I characterize it, came under pressure not with respect to the functions, but with respect to the claim that these functions were allocated to distinct institutions. The development of the administrative state led to the accurate perception, that in the administrative state, executive agencies in particular were also making rules of the sort that looked like legislation and adjudicating disputes. And similarly, although less dramatically, there were legislative agencies or legislative bodies that were resolving particularized controversies and specifying in some detail how the law should be carried out. So the development of the administrative state led to the understanding that the Montesquieuian functions were fractured and allocated among different institutions. The next development, which is, I should note that this fracturing led to sort of a conceptualization of the administrative branch as a 4th branch of government. The next development was at the beginning of the 20th century, and carrying through roughly the first half of the 20th century. I associated with Hans Kelsen, who is the inventor of the Constitutional Court. And Kelsen noted that in addition to the functions that Montesquieu identified, there was a fourth function that all constitutional systems had to perform, which was the preservation of the Constitution itself. And for Kelsen, the function of preserving the Constitution, protecting the Constitution, was to be performed by a constitutional court. I should note, for completeness' sake, that there's some, there's at the time Kelsen did this, a controversy arose between him and his much more conservative interlocutor, Carl Schmitt, where Schmitt agreed that there was a function to be performed of protecting the Constitution, but believed that that function was performed by already performed by the executive. For reasons that I don't want to go into now, but if we want to talk about it later, we could. Ultimately, Kelsen's conceptualization prevailed over Schmitt's. The function that Kelsen identified of protecting the Constitution is, like the other functions, universal. A constitutional court in an authoritarian regime would have the function of protecting the authoritarian leadership from challenge. But of course, those who theorize about constitutions focus on democratic regimes, and in such regimes, the concern is, again, with the institutions for protecting constitutional democracy. Again, now to go back to the story I developed, the rise of the administrative state showed that the Montesquieuian functions could be fractured and distributed among many institutions. In the late 20th century and into the 21st century, constitutional theorists and designers discovered that the same thing was true about the function of protecting constitutional democracy. That function, the function of protecting a democratic constitution, could be fractured and distributed among various institutions as well. Professor Harding indicated some of these institutions. The South African Constitution has a separate chapter called Institutions Supporting Constitutional Democracy. And when you look at that chapter, what you see there is among the institutions are the public protector, the state auditor, and the election commission. In other constitutional systems where you see this kind of grouping, you will see some version of an anti-corruption agency. And note, in South Africa, the anti-corruption agency is statutory, but over the course of the past decade, as a result of serious political controversies associated with corruption, the South African Constitutional Court has more or less transformed these statutory institutions into constitutionally embedded ones. Modern constitutions around the world typically contain a roughly similar set of these IPDs. And what I'm going to talk about tonight is a preliminary inquiry into some of the constitutional design features of these institutions. I'm going to combine a brief, mostly descriptive examination of some interesting examples of IPDs and their behaviors with some mostly normative speculations about what the implications of the logic of IPDs might be for institutional design. Now, first point is that it's important, to me at least, to define the inquiry appropriately. You might describe, and when I've done this in earlier versions, these issues have come up, you might describe a large number of arrangements as designed to protect democracy. One account of the overall system of separation of powers argues that the system protects democracy by preventing the accumulation of power in any one person's hands. Similarly, a vibrant civil society can be said to protect, indeed, to be essential to democracy. To avoid sweeping everything into the category of institutions protecting constitutional democracy, I treat the category as dealing with institutions whose specific charge is to protect one or another dimension of democratic function, such as electoral fairness in the case of election commissions, or the use of public funds for public purposes in the case of audit bureaus. And then the logic of the institutions is this, and I'll talk about this in some detail as I go along. Why do you create these institutions rather than leaving their work to the Montesquieuian branches? The logic is, I think, that those branches are placed in a situation of conflict of interest when particular cases challenging democratic functioning arise. So Kelsen saw that was experiencing systemic conflicts between legislatures and executives. He said, again, in my interpretation, which is, I've come to know, controversial among scholars of Kelsen's work, he said, well, there's this third branch, the judiciary, which might be seen as able to adjudicate without facing a conflict of interest. But, Kelsen believed, legislative-executive conflicts had a particularly political dimension, which the characteristic commitment of the judiciary to legalism would not perform well. I didn't say that very clearly, but the idea is that give these executive legislative conflicts for resolution to the ordinary courts, they will apply too legalistic a standard, as in some sense they should, to a controversy that combines law and politics. And so Kelsen said we needed to design a separate institution that was able to combine law and politics in an appropriate way. Similarly, with respect to elections, legislators can't be trusted to set district boundaries without attention to the effects that doing so will have on their prospects or their party's political prospects. Now, we've learned that the Montesquieuian functions can be distributed among several institutions, and contemporary constitutional design shows that it actually is. One important question is whether it should be so distributed. One thing that one observes is that the functions are not always distributed. In particular, constitutional courts in many countries have been given a variety of these tasks. They resolve election controversies. They become the supervisors, at the very least, of corruption inquiries. My favorite example of this is that under the current Brazilian constitution, likely to be amended soon, but under the current Brazilian constitution, charges of criminal misconduct by members of Congress are tried in the first instance in the Supreme Federal Court. The Supreme Court is a trial court for criminal cases against members of Congress. And those cases are heavily corruption cases. Okay, so you could do it, and many places do concentrate these functions in a single institution, the Constitutional Court. The logic of these institutions, I think, is, in addition to the conflict of interest concern, that the task of protecting democracy has several components, and the requirements for doing one part of the job well might well be different from the requirements for doing another part well. Just again, as an example, take audit bureaus. Tracing money from its appropriation to its expenditure is a complex task that legalistic judges might not be able to perform well, or might not be able to perform well as a separate audit bureau could perform it. The forms of expertise clearly differ depending on what aspect of democracy is at stake. Again, if you have an audit bureau, it's going to be staffed by people who are very good at tracing money, call them CPAs, certified public accountants in the US terminology. They're not going to be very good at thinking about the political dimensions of electoral boundary drawing or qualification of parties for the ballot, and so on. That's the case for multiple institutions, is that there are multiple kinds of expertise that are at stake. I'm now going to turn to a sort of, as I said, an informal survey of different IPDs and the tasks each performs, and then attempt to discern some common features that might affect institutional design. I think I have three major examples here. The first is electoral commissions. The authority of electoral commissions varies, as do the details of their composition. And here I'm going to abstract from many of the details. A more extensive survey of design choices might modify some of the claims I'm about to make. Okay, so what are the tasks of an electoral commission understood as designed to promote constitutional democracy? Well, for identifying parties to be placed on the ballot, or maybe more important, parties that will not be allowed to appear, ballot inclusion and ballot party banning, basically. They might require that a party or individual candidate demonstrates sufficient support among the public before being listed on the ballot form, or they might be given the task in a militant democracy to disqualify parties whose programs are inconsistent with the Constitution's fundamental premises. The ballot listing job is largely routine and technical, counting and verifying signatures on a petition to appear on the ballot. The party disqualification job is highly charged politically, and that's relevant to the design questions that you need to answer. Other tasks for election commissions include supervising the conduct of elections, including policing political advertisements for fairness and accuracy, determining whether the processes of voting and ballot counting are free and fair. They can also draw district boundaries with an eye to something like electoral fairness, some combination of one person, one vote, with concern for securing appropriate representation of important geographically concentrated interests, or in the peculiar case of Hong Kong, maybe identifying sectoral interests, non-geographically located, that deserve representation. Now, electoral commissions are deeply implicated in politics, but they're not expected to be entirely political. Nations with such commissions believe that there are standards like fairness to be applied. A fair process is one that produces outcomes the losers can live with, which is to say, fair processes must satisfy political actors that they've been treated fairly. And that inevitably subjective element has some implications for designing electoral commissions. In nations with well-defined and reasonably stable parties, the Electoral Commission has to have a balance of partisan interests. The design issues for nations with less well-organized, more fluid party systems or more complex, partisan balance is, for all practical purposes, impossible, because those designing the system can't know what parties they have to balance. So what do? Well, designers say you choose disinterested people, meaning people without significant histories of partisan involvement. Give civil society organizations a substantial role in selecting members of the Electoral Commission. I'll give you an example from the Constitution of Venezuela. Venezuela is not a great example for constitutional democracy. This design choice actually seems like a sensible one. It requires that the members of its electoral council have no ties to organizations for political purposes, and it gives civil society organizations and law schools and university political science departments a majority vote in nominating members of the commission. Okay, so that's on the sort of expertise kind of side. For these commissions to function effectively, the members must be relatively independent from direct political control, and the qualifying words, relatively and direct, are important. Direct political control would make it impossible for the commissions to protect democracy against threats from the Montesquieuian branches. But too much independence would deprive the commissions of the political support they need if they're to survive. And again, the solutions here in principle are fairly obvious. First, require that the members of the commissions be confirmed by the Montesquieuian branches, including the possibility of judicial participation in confirmation, but limit the range of choice of those branches have by presenting them with a closed list of potential members generated by the kinds of processes I've just suggested. In the United States, there's an independent redistricting commission in the state of Arizona. It has 5 members. The state's commission on appointments to the appellate courts compiles a list of potential members, can include those who hold public office. The majority and minority party leaders in both of the state's legislative chambers choose 1 member each from this list of potential members, and the 4 party chosen members pick a 5th member from the list. So again, that's a way of ensuring independence while also getting partisan party buy-in to the outcomes. That's at the selection stage. The second, give the members fixed and non-renewable terms longer than the terms of the legislature and the chief executive, so that they can't, that the commission can't be captured in a sort of standard way. More difficult to implement, stagger the terms so that at every point the commission has some members chosen before the present legislature and chief executive took office, and we'll have some members who remain in office when the present legislator and chief executives leave. Okay, so that's, again, a sketch of the electoral commissions. Turning now to anti-corruption agencies, the first observation I want to make is something that comes out of the literature on anti-corruption, which is design choices have no consequences for actual effectiveness of anti-corruption enterprises. Institutions with the same design succeed some places and fail in other places. Institutions that fail in some places succeed elsewhere. The literature suggests that what really matters is some degree of sustained commitment to anti-corruption as an enterprise by the nation's political leadership. Then whatever institution they put in place is going to work, and if they don't have that commitment, no institution in place is work. So what I'm talking about here are design choices that seem to me fit into the sort of analytic framework I'm developing, but are not choices predicated on ideas about success in eliminating corruption. The first observation, this is standard in the literature, that we might want to distinguish between corruption at the highest level and corruption by low-level officials. Corruption at the low level threatens the legitimacy of any regime, not merely democratic ones. At the highest level, most regimes, even if they're corrupt at the highest level, would like to eliminate corruption at the lowest level. Because when the citizenry confronts corruption on a day-to-day basis, it really undermines the stability of the system as a whole. So institutions devoted to identifying and eliminating low-level corruption are not intrinsically institutions protecting democracy. They're institutions protecting the regime, whatever it happens to be. That might be true as well with institutions charged with identifying corruption at the highest level, but it might be that there's something special in democratic terms about a high-level corruption. The thought which is captured in some of the South African decisions that I alluded to earlier, the thought might be that democratic legitimacy rests disproportionately on the faith in the public, that those who they have chosen as leaders are interested in pursuing the public good rather than private gain. Okay, so there's a case to be made for treating anti-corruption agencies as institutions for the protection of democracy. The primary difficulties associated with anti-corruption agencies appear to be overzealousness on one hand, and its opposite, failure to pursue serious claims that a high-level official has engaged in corruption. The controversies in South Africa have been about, in some ways, both of those, overzealousness in pursuing the enemies of the current president, the then current president, and neglect of corruption claims against that president. In Brazil, the current experience appears to be one of a systematic overzealousness. My Brazilian friends tell me that I shouldn't use this example because doesn't capture the entire story, but my version of the overzealousness is the prosecution and imprisonment and disqualification from running for office of Lula, the leading candidate, on a charge, maybe accurate, of accepting a fairly modest payment from a governmental contractor to renovate an apartment that he owned. The amount that he was convicted on was relatively small. My Brazilian friends tell me, yeah, but there was a lot of other stuff going on that they didn't have to convict him for. Okay, so overzealousness and failure to investigate. These difficulties arise from the deeper difficulty of determining precisely how independent the agency should be of high-level political control. If you set the independence too low or set it at a level perceived to be too low, and you face problems of under-enforcement, and perhaps more important, as I just suggested, selective enforcement, or almost equally problematic, difficult to refute charges of selective enforcement. So it should be clear why under-enforcement might be a problem. There's also a problem of overzealousness, and this is harder to pin down. The line between corruption and the activities politicians engage in to build their parties and to ensure their reelection is often quite thin. Determining whether a politician received a contribution for his or her private use, as in the Lula example about the apartment, or rather received the contribution for building the party or financing a campaign will sometimes be difficult. And so one version of this in Brazil is that the people charged with running the political parties don't get paid very much by the parties. So they receive contributions to their personal benefit, supplements to their income from outsiders. That's clearly corrupt. At the same time, it's clearly easy to describe that as corrupt. At the same time, they're performing an important function, which they couldn't perform if they weren't paid adequately. And so the function is to make sure that the parties work well. What that means is that an overzealous anti-corruption agency might pursue a corruption charge against someone who engaged in more or less ordinary political fundraising and reciprocated with more or less ordinary patronage. You know, giving, you get a political contribution, you get a contribution from a contractor, and the contractor submits a bid that is a little higher than the lowest bid, and you give the contract to the contributor. It's not great because there's a cost. On the other hand, the contribution went to the party, and having stable parties is actually a pretty good thing. Another difficulty with too much independence is that the head of the anti-corruption agency can build a constituency to support him or her, not merely in the agency's current work, but for a future campaign for elective office. Selective enforcement occurs when the anti-corruption agency takes out opponents of the agency's head's political allies. Ambitious enforcement occurs when the agency takes out potential opponents in a future campaign by the agency head. There were charges, there are claims rattling around in Brazil that the lead judge in the major Brazilian anti-corruption investigation harbors in the back of his mind the prospect of running for president someday. He's denied that, and he's not running in the current election, but he's also young, and he's building a reputation. Similar claims have been made about the South African ombudswoman, appointed as basically a party hack who discovered that she could become a significant political figure by doing the thing that ombudspeople do, responding to to complaints about maladministration at the level of individual cases. And she became a significant political figure. Okay, the third, so I've talked about electoral commissions and anti-corruption agencies. The third I just want to talk about briefly is constitutional courts. They were the first such institutions. The literature on their design is vast. For present purposes, I just want to reiterate the core insight underlying the design of Kelsenian constitutional courts. And that insight was that though such courts are engaged in interpreting the law, their law that they're interpreting, the Constitution, necessarily has important political components. Having a civil law tradition of judicial appointments to the ordinary courts in mind, Kelsen understood that a constitutional court could not be just another hierarchically superior institution within the ordinary judicial system. Promotion with the ordinary courts rested on criteria that didn't take the political component of constitutional law into account. So for Kelsen, as I interpret him, members of the Constitutional Court had to be chosen outside the ordinary courts. They would have to be lawyers, of course, because they would be doing law, but they would also have to have, or at least some of them would have to have, significant experience in or familiarity with how the nation's politics operated. Okay, there's more to be said about constitutional courts, but I need to move on. So now let me turn to the general themes. Two themes run through the foregoing descriptions. Each IPD focuses on a task that the Montesquieuian institutions might mishandle because the participants in those institutions have incentives that skew them away from performing the IPD's tasks well. Again, the political interest of legislators in drawing boundary lines is obvious. The second theme is expertise tempered by sensitivity to politics. You might think that constitutional courts could perform the task given to electoral commissions because they are, or they could be by good institutional design, disinterested observers of politics rather than participants in it. Even so, you might think that drawing district boundaries has policy components, to use language from US law, ensuring, for example, ensuring that communities with a common interest are in a position to elect representatives of their own choosing. And judges might be insufficiently sensitive, and as I said earlier, properly so, to these policy consequences. The standards for determining fairness in the conduct of elections are, at best, distantly related to standards found elsewhere in the law, and judges accustomed to applying the law might have difficulty devising appropriate definitions of electoral fairness. Again, with anti-corruption agencies, as I said, drawing the boundary between true corruption and political patronage is a difficult task, or can be a difficult task, and it has to be performed with a degree of sensitivity to the way politics actually operates that constitutional court judges trained as lawyers might not have. Also, judges on constitutional courts are typically not selected in ways that would give them the conceptual resources to identify the ways in which resources might be diverted to private uses. Here I have in mind a provision in one of the recent Latin American constitutions that specifically refers to the difficulties of identifying money laundering and says we're going to create an agency that knows how to trace money to its source. Okay, so now the idea of politics at work in these observations about the capacity of constitutional courts is reasonably clear. A little more about the idea of expertise. We conventionally regard judges as experts in law. Their professional commitment to the rule of law gives them the intellectual resources to resist, to some significant degree, we hope, merely political pressures. Auditors are trained to track expenditures, to follow the money trail. In pursuing corruption, they may face political pressure, but the idea is that their professional commitment to honest accounting gives them an ideological resource, like the rule of law commitment judges have, that allows them to resist that pressure. Okay, now, there's a related problem that the examples I've given point to. These institutions exist because those who staff them have some forms of expertise, but we know that experts are often mission committed. That is, they believe that their expertise dominates all other considerations. And mission committed IPDs, with the impedance that they have to have, can do too much. A common observation in the literature about censorship boards, not one of these institutions, but is because the job of a censor is to censor, censorship boards will censor too much. Constitutional courts dominated by lawyers will find law regulating more domains than is appropriate. And as I've suggested, anti-corruption agencies will find corruption everywhere. So then if you have this idea of mission commitment in mind, what can you do about it? Well, maybe designing the commissions, the institutions would work. The professional identity of some judges on Chalcedonian courts is as lawyers, but such courts are designed to ensure that other judges identify less with law and more with politics in a broad sense. Multi-member institutions are less subject to mission commitment than single-member ones. And this suggests that the relatively common practice of naming a single person to head an anti-corruption agency, which you do to ensure accountability, might be a mistake. It might be better to have a three-person agency doing it. Another mechanism would be to provide review of the decision of the agency in a way that doesn't substantially interfere with independence. The obvious candidate is the Constitutional Court. The relationship between the Constitutional Court and these institutions is not much explored in the literature. May the Constitutional Court halt an anti-corruption inquiry on the ground that the procedures being used fail to comport with the court's understanding of regularity and due process? You might worry about that because the court's legalistic conception of regularity and due process may not be suitable for the anti-corruption enterprise. Regularity and due process might take different forms from those to which judges would incline. Similarly, and maybe more dramatically, could a Constitutional Court inquire into whether the anti-corruption agency has too much or too little independence of political control? The tools provided by legal analysis, which are the only tools the Constitutional Court can use, may not be well adapted to determining how much independence is enough. Here, the South African story, which I obviously can't go into detail, is quite interesting. The South African Constitutional Court has intervened quite substantially in anti-corruption inquiries. The legal analysis it's provided for its outcomes is, from my perspective, strikingly weak. And yet, it's worth saying, the outcomes turn out to be quite defensible. Okay. Let's see. Is there anything? I'm running out of time. I guess one of the thoughts here is that there will be a temptation to use the Constitutional Court to supervise the other institutions. That may, whether it functions well, may depend on the content of the constitutional law it develops, and that may be a function of the court's own mission commitment to legalism. Review of procedures capitalizes on judicial specialization and procedure, and so on. The thought here is that if, as I think is likely to happen, the Constitutional Court ends up as being the supervisor of all these agencies, it ought to be cautious about adopting an aggressive standard of review. It ought to be reasonably deferential to the choices that the agencies make. I think I'll just wrap up now. What I've said is quite preliminary. I think the category is an interesting and useful one for studying constitutional structures generally. What characterizes these institutions, though, requires additional examination. I've suggested some possibilities, such as the inadequacy of the traditional branch's incentives to address problems of protecting democracy, and the varying combinations of expertise and independence required to address specific problems of that sort. My guess is that in the end, we're going to find that these institutions share something like a family resemblance rather than satisfying necessary and sufficient conditions. I should note that the next task in my own project is to conduct a more systematic survey of these institutions and national constitutions to get better sense of the design options that are both available and that have been chosen to create them. With that, I think I will conclude, and I await Andrew's comments and then questions from the audience. Thank you.
Well, thank you very much, and thanks very much to Professor Mark Tushnet for a lecture of almost really breathtaking breadth and implication in terms of how we can protect our democracies from the threats which seem to increase almost on a daily basis. One of those threats is actually within our control in the sense that we may suffer from poor design choices. And I think Professor Tushnet has given us some extremely wise thoughts and raised some very important questions about how we could improve those design choices in order to protect our democracies from being undermined from within. We don't have too much time, and I'm sure you have lots of questions, so I'm going to pause there, and it's over to you. Please come up to the mic and tell us who you are. James first.
Okay, so I'm James Penn, a professor here at NUS. I don't have anything remotely intelligent to say about the institutions that you were talking about, but I wanted to ask you to speculate about other institutions which might, on some grounds, be regarded as democracy-protecting institutions. So in the United States right now, there seems to be an ongoing conflict about what the role of the FBI is in its relation to the executive, about whether it also has a function. But I wanted to ask you more generally about those mechanisms of the state that have actual coercive force in their hands, for example, the military. So I believe there are some states under which the military, as part of its remit, the protection of the democracy of the society. The only examples I can think of are the interventions by the Turkish military forces on the ground that they were actually protecting the state and so on. And whether, so I'm really just asking you to speculate because I was interested to hear what you had to say.
Right, so Thank you. That's a really interesting and important question, which is on the agenda for the project. Let me preface that by saying the usual observation that I get in this connection is about environmental protection agencies and central banks, where the conflict of interest point is clear between the present and the future. The question with respect to the military is whether there is whether we can identify a systemic problem of threatening democracy to which military intervention is a systemic response. Clearly, in some instances, it is. The Turkish examples are good ones. There's a recent book, I forget the name of it, but it talks about pro-democratic coup d'etat by Ozan Vural. I think his category is overbroad, and I think it's interesting. I'm not sure. Well, I guess I would say my inclination is to think that while I can talk about central banks within my framework, I don't think that I can talk about the military within my framework. There may be another framework that is suitable for it, but my inclination is to think it's not going to work here. So there I think the answer is the more or less universal modern choice is to give those kinds of agencies, to give them constitutionally grounded independence. In the US, we're stuck with an old constitution. And so we have to say, well, there are norms of independence that are associated with these kinds of institutions. Almost every other modern constitution, or almost every modern constitution, sticks the public prosecutor or the attorney general into a separate category, into this separate category. And I find it interesting that in South Africa, where the anti-corruption agency is not in the Chapter 9, the Constitutional Court has given the actors essentially constitutional status in a series of decisions.
The examples that you gave of the particular case studies of IPDs generally are not considered to be successful constitutional democracies, South Africa, Brazil, Venezuela. I'm wondering if you have examples of IPDs which have operated effectively to shore up a fragile constitutional democracy or to pull a fragile constitutional democracy back from the brink of some sort of democratic collapse. Now, I'll answer your question. Arguably, the ICAC, Hong Kong ICAC, Independent Commission Against Corruption, in the 1970s, some would argue that did that. So that's at least one example. But do you have other examples of where these have actually effectively intervened to preserve what would otherwise have been a fragile political democratic system?
I think the honest answer is no. I don't have any. I guess my response, I don't know that this is a response, but my observation is there are very few examples of systems that have become fragile actually pulling back from the brink. And we need case studies of those. Sam Zakharov has a book called Fragile Democracies, and it says, well, constitutional courts could perform the function of boosting fragile democracies, but when you read the book, the case studies he has are just, they don't make the case for constitutional courts, even for constitutional courts. So I think that the way, this is not how I would, well, this is not what I would do, but I think the way to do it, to do that kind of study, is to find, well, find fragile democracies that were pulled back from the brink and fragile democracies that went over the cliff, and see what characterizes them. In the modern so I think there's a tremendously interesting study to be done of what happened in Ecuador, where a decade ago, everybody was describing Ecuador as one of these endangered democracies because of the charismatic leadership of Rafael Correa. It turns out that Ecuador came back, if it was ever on the brink, it came back from the brink. But nobody, I don't know of anybody who has yet studied why it happened. The surface story is that Correa was betrayed by his hand-picked successor. But there must be more to the story.
Damien?
Thank you very much. I'm Damien Chong, also a professor at NUS. My question goes to how do you ensure, what would your suggestion for how IPDs secure balance, where the competition between democratic groups is very intense? I'll give an example. You know Brazil, which I know reasonably well, know Argentina better. And my understanding in Argentina and Brazil is politicians are sent through the courts because their political competitors want to bar them off, not to put them in prison. Right. Politicians are pursued through the courts for corruption, largely because their political competitors want to bar them from office. This is the case of Brazil, and Cameroon, Kirchneristas are being pursued that way in Argentina. And that's one problem, is that secure competition, no corruption. You minimise party competition, but you also, at least do more basic thing, politicians in South America do very menial things, because they're worried about the risk of being perceived for corrupt office. So in regional organisations, things that are done by local civil servants, politicians are actually at meetings, which might be a democratic cost. Now you'd say, well then for maybe IPD should be less zealous, which you suggested in the lecture. But you also have a situation on the other side where, since Collor in Brazil and then in Argentina, the majority of Argentine and Brazilian presidents have been subject to pretty strong allegations, well-founded allegations, of corruption, and that goes through high tiers of government. So the corruption cost is a high thing. So the competition in both cases is very intense. How does a anti-corruption agency deal with that?
I don't know the Argentinian story. My take on the Brazilian story is that, again, my Brazilian friends challenged me on this characterization, but that the major investigations have been done by the judiciary, by judges, and by crusading judges in particular, certainly in the current example. And so they're not done by what I would characterize well-designed anti-corruption agencies. And that may be why the Brazilian story is one in which, I think this is right, the pursuit of corruption has destroyed the party system, made a stable party system impossible, which is a threat to democracy. And so what, corruption is bad, but the good of stable parties is also pretty good. And the thought is that independent anti-corruption agencies, if they are well designed, might strike the balance better than the current system has done. The Singaporean and Hong Kong examples in the anti-corruption literature do stand out but again, as I said at the outset, it's not clear that institutional design mattered for their success. I have to say, on my flight here, I watched a movie made in Hong Kong about, I forget what, an anti-corruption investigation called something like, it had Z in the title. And literally, the next to last line of the movie had the 5 anti-corruption investigators sort of walking down the street like the gunfighters in a Western movie. And the next to last line was, as long as there's corruption, there will be the ICAC to fight it. I was really struck by that. The last line was, oh, you're just saying that to make yourself look good. So, a little edge to it, but anyway.
I think Z is the title, isn't it, of that movie? If it's the old one talking about corruption in Greece.
No. This is in Hong Kong.
Oh right, okay, all right. Jacqueline.
I yield to the student.
Dave, a student. Yeah, okay. I was requested by the Vice Dean to talk about Singapore, so I shall. So we talked about IPDs and how they're meant to sort of support democratic institutions generally. But is there a possibility for us to have an executive in charge of an institution that protects democracy? So for example, in Singapore, we've got the Electoral Commission that's under the Prime Minister's office. And a lot of people see that to be problematic. But is it actually? Can they coexist?
So I want to look at things in detail, and one observation here is a sort of general methodological observation about comparative constitutional studies, which is I look at things, as my language tonight indicates, in functional terms, and then say, but the functions are performed in varying ways in different systems, and sometimes the variations will be more significant than the functions. And so you need to look at precisely what was going on. The general concern would be, and this would be the following, and then I'll modify it in terms of Singapore, that some of the threats to democracy emerge from the executive government itself. And if the institution to protect democracy is lodged, protect democracy with respect to that kind of threat is lodged within the executive, then you have the conflict of interest problem that motivates the creation of these as separate institutions. The qualification to that is that, as I said in connection with something earlier, sometimes norms, either professional norms or civic norms, can be one of the things that offsets the conflict of interest. Norms rather than institutional separation. And so it might be that lodging some of these institutions within the executive would be okay if the thing that they were targeting, if the task that they were targeting, the task of eliminating what they were targeting, had behind it very strong professional norms. Again, for me, auditing is the clearest example of that.
Jacqueline?
So I have sort of two questions. One is, what is your...
If you have two, can you keep it very brief because we're already out of time?
Okay. One, so are institutions protecting democracy democratic? Because I suppose this pushes back against your functional approach, because what is your basis for for legitimacy? Is there one theory of legitimacy that you have in mind to justify what they're doing? And secondly, which is related, is how do we keep them accountable? I'm always struck by something that Don Horowitz said when he was here earlier this year, that the Indonesian Constitutional Court is very independent, but also quite corrupt. That's what he said, not his words, not mine. So so certain institutions can be very independent, and yet you can't keep them accountable.
Right.
So how do you deal with that?
So the design problem is precisely independence and accountability. And as coming to this topic from the field of US constitutional law, that's what the scholarship in constitutional law is about. The counter-majoritarian difficulty and all that sort of stuff is about how we can have a court that combines independence with sufficient accountability. So I think the design issues are not different from familiar ones with respect to constitutional law generally. I do think that the resolution is going to be different. Just as an obvious, so the norm for the length of tenure of constitutional court judges is somewhere between 9 and 15 years. The norm for these agencies is shorter than that, but longer, as I said, longer than the terms of Parliament. It's that kind of thing that we need to think about. But it's the kind of thing that we've been thinking about in the domain of constitutional law or constitutional courts for a long time.
Arif, you have 11 seconds.
So I received a little bit of attention in your presentation. And you talked about the anti-corruption, but perhaps incorrectly, so please correct me if I am wrong. When you talked about anti-corruption commissions, I think the point you're making was that a similar design commission could work in one place, but not in another. And this is leading me to think about whether or not the answer is really to be found in the design issues that we're talking about, or it's to be found in something else, like political culture. Whether it's the political culture that really can help to protect democracy. So in the United States, of course, recently the president has said, I have an attorney general. The attorney general hasn't replied to say he has no president, but maybe he will. But President Trump, expresses, let's say, a particular political culture. Another president might express a different sort of political culture. But that seems to me to be one of the challenges, not just in the United States, but other places. So I'm wondering about the relationship with political culture.
Yeah, so I think that's clearly, you're not mistaken in discerning attention, okay? The position I've come to on this is one of, I think of it as specialization of labor. So in the anti-corruption context, institutional design doesn't seem to matter, political leadership does. As a person who thinks about constitutions, I can say something coherent about institutional design. I can't say anything coherent about political leadership. That's for political scientists. They have expertise about that. Similarly, with the rule of law kinds of concerns that you're articulating, I think those are sociological concerns, civil society kinds of things. And, you know, I can wave my hands about them, but I really don't know anything. I know about designing constitutions, so that's what I'm going to write about. When this project is completed, there will be a non-trivial discussion of both the general methodological point that I mentioned earlier and this particular division of labor point, which is an important one. But I don't think it defeats the enterprise. Neither the methodological concern nor this division of labor concern defeats the enterprise. It just says, you know, take from this what you find interesting. Don't take it as, you know, prescribing solutions for anybody.
I'm going to have to be an institution preventing democracy at this point and call time on the proceedings because we're already well over time. But it truly has been a fascinating lecture and a fascinating discussion with some extremely good questions and interesting answers. I'm sure we could go on for a very long time, but perhaps if you have burning questions, Professor Tushnet might be willing to entertain those between munching on the buffet dinner afterwards. But sincere thanks to Professor Tushnet for sharing his great wisdom with us this evening, and thanks to you all as well.